If you have a challenge against the jurisdiction of the arbitrator, you will approach the arbitrator himself and he will decide upon his own jurisdiction. And you can challenge it in appeal before the tribunal. And you have another provision, section 17. Section 17 is similar to section 9, where interim measures can be granted by the arbitrator or the arbitral tribunal. And those interim orders can be enforced as if it is a order passed by a civil court. There is a provision in section 17. These are the circumstances under which this court interference will happen. And it is very limited and designed in such a way that the arbitration process should continue. And insofar as other challenges like arbitrators challenge, if you challenge the arbitrator saying that Schedule 5, your relationship, the arbitrator's relationship falls under Schedule 5, you don't have a right to challenge immediately. You will have to wait until the arbitrator passes an award. You can challenge it under 34 only. You don't have an appeal from a challenge of the arbitrator. Then we go to the next topic, and that is duties of the arbitral tribunal. This duties of the arbitral tribunal is very, very important as far as England is concerned, because there is a very, very serious consequence that follows if you violate these duties. Basically, I would always say that once I have even written an article about this, because this duty business is an Indian business. We always speak about duties. Pidru Dharma, Putra Dharma, Raja Dharma, and so on. We had a professor who used to say that Indian constitution failed on the day when it is in 1950 itself. And his explanation was that you have copied many things from across the globe, including the fundamental rights, and India was not ready for enforcing these fundamental rights. They were more concerned about duties. And whenever the duties are performed, the rights of people, if suppose I am a teacher and I am performing my duty well, and the people sitting on the other side are students, their rights are automatically protected. Rather than we saying that the student has a right, once we say that student has a right, there should be an inspector to look into this question as to whether the student's right is protected. Then you will have a supervisor for the inspector to see whether that inspector is doing the work properly. Then you should have a court to adjudicate the dispute as to whether the inspector has taken action properly. If the teacher doesn't do his work, put him in jail. Then the protection of all the rights of all the teachers, all the students are automatically protected. And our professor used to argue that the problem with the Indian constitution was that you were never focusing on the duties. And when you tried to incorporate duties, you did not give the necessary respect to the duties. Now we find a law in England who were always talking about rights, speaks about duties for the first time. I believe it may be the first time where they are talking about duties. And therefore, the duties of the arbitral tribunal. And the consequence is also very evident. The consequence is contained in section 68. I will show you after this slides. If the arbitral tribunal fails to discharge its duties provided under section 33, it would amount to a serious irregularity, and for that single reason that the arbitration award can be set aside. So we are not talking about this public policy business and trying to interpret public policy. They have a very straitjacket list of items which contain serious irregularities. And when the serious irregularities is found by the court, the arbitration award is set aside. So that is the importance of of the duties. And we may find similarity with the principles which we have already discussed. Act fairly and impartially between the parties. The tribunal shall act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of the opponent. And adopt procedure suitable to the circumstances of the particular case, avoiding unnecessary delay or expenses so as to provide a fair means for the resolution of the matters falling to be determined. The tribunal shall comply with the general duty in conducting the arbitral proceedings in its decisions on matter of procedure and evidence, in the exercise of all other powers conferred on it. So they have two duties: to act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of the opponent, and adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expenses so as to provide a fair means for the resolution of the matter falling to be determined. So these are the two important duties of the arbitral tribunal. So there are duties for the parties also under this act. The party shall do all things necessary for the proper and expeditious conduct of the arbitral proceedings. Comply without delay with any determination of the tribunal as to procedural or evidential matters, or with any order or direction of the tribunal, where appropriate, taking without delay any necessary steps to obtain a decision of the court on a preliminary question of jurisdiction or law. So the party should be very vigilant, and the consequences for violation or failure to comply with the duty, failure to comply with the failure of the arbitral tribunal to comply with the general duty under section 33 of the Arbitration Act, this is the English Arbitration Act, amounts to a serious irregularity, and the award can be set aside on that single reason under section 68 of the Arbitration Act 1996. Failure of the parties to comply with the general duty under section 40 will have the consequences that are contained in section 41 of the Act. Power of the tribunal in case of parties default. So here again we will find that the parties are free to agree on the powers of the tribunal in case of the parties' failure to do something necessary for the proper and expeditious conduct of the arbitration. Unless otherwise agreed by the parties, again, party autonomy is respected. The following provisions apply. If the tribunal is satisfied that there has been inordinate and inexcusable delay on the part of the claimant in pursuing his claim, and that the delay gives rise to substantial risk, then the consequence will be the dismissal of the claim. Then, without sufficient cause, a party fails to attend, then the consequences is explained. If without sufficient cause, the party fails to comply with any order, then the consequences explained. And these consequences are attached to section 40. 40 violations ulla consequences, peremptory orders pass ആക്കാം, cost impose ചെയ്യാം, parties ഏത് തരത്തിൽ വേണമെങ്കിലും നശിപ്പിക്കാം. the tribunal will have the such kind of a power. And I will also take you to section 68 to just give you a glance about the and you will find each and every topic has been discussed in detail. If suppose the model law speaks about awards, you will have very clear idea as to how the award should be prepared, and the entire thing will be statutorily included. When we speak about procedural and evidentiary matters, you have a list of things included there, and you need not have, you are guided perfectly by that statute. Here we will seek guidance in precedence, and which is more confusing, and it will create a very difficult life for an arbitration prof. So we come to section 68. I just wanted to show you this because you need to compare this provision with section 34 of our Arbitration Conciliation Act. A party to arbitral proceedings may, upon notice to the other parties and to the tribunal, apply to the court challenging an award in the proceedings on the ground of serious irregularity affecting the tribunal. The proceedings of the award, a party may lose his right to object, and under section 73, and the right to apply in is subject to the restrictions in section 72 and 3. In clause number 1, you will find that proceedings can be challenged on the ground of serious irregularities. Now you come to section 2, so subsection 2. You have a list of items. Serious irregularities means an irregularity of one or more of the following kinds, which the court considers has caused or will cause substantial injustice to the applicant. A, failure by the tribunal to comply with section 33 general duty of tribunal. B, the tribunal exceeding the powers otherwise than by exceeding in its substantive jurisdiction, see section 67. Failure by the tribunal to conduct the proceedings in accordance with the procedure agreed by the parties. Failure by the tribunal to deal with all the issues that were put to it. Any arbitral or other institution or person vested by the parties with powers in relation to the proceedings or award exceeding its powers. Uncertainty or ambiguity as to the effect of the award being obtained by fraud, or the award or the way in which it has been procured being contrary to public policy. Failure to comply with the requirements as to the form of the award, or any irregularities in the conduct of the proceedings or in the award, which is admitted by the tribunal or by any arbitral or other institution or person vested by the parties with the power in relation to the proceedings or the award. Now the consequences is that if serious irregularities are affecting the if there is shown to be serious irregularities affecting the tribunal, the proceedings or the award, the court may remit the award to the tribunal in whole or in part for reconsideration, set the arbitration, set the award aside in whole or in part, or declare the award to be of no effect in whole or in part. The court shall not exercise its powers to set aside or to declare an award to be of no effect in whole or in part unless it is satisfied that it would be inappropriate to remit the matter in question to the tribunal for reconsideration, the leave of the court is required for an appeal from the decision of the court under this section. So there is a very clear understanding in the minds of the lawmakers that what should be a serious irregularity and how the award should be set aside. I'm not reading 34. You may take your time reading 34. You will find ever so many changes. And my understanding is that the principles of arbitration, as well as the duties and duties of the parties and the duties of the arbitral tribunal, can be a guiding principle for any arbitrator or an arbitral professional when you are given an assignment of to arbitrate, because you are not guided by the code or evidence act, but you can very well be guided by the principles of arbitration and the duties of the arbitrator, because we will find that Arbitration Act 1996 of England is a good version of the UNCITRAL model law, because they have done their assignment much better than their Indian counterparts who has copied the entire thing. That's all that I want to point out. Thank you. If you have any questions, I can attempt to answer, or I will try to find out the answer and share with you in the Moodle platform or in the group. So next session is on next Saturday, where we will be talking about, now we are not anymore talking about what do you call academics. We are going to talk practical things about arbitration. We will be talking about role of next Saturday. Fifth. We will be talking about case management, preliminary hearing, challenge against the arbitrator, challenge against the jurisdictional challenge under section 16, and I will share the list. In the meantime, we are also planning 2 sessions. I think that next week we will not have any sessions in the weekdays. That will be next Saturday, and thereafter on 10th, Justice Dias will be talking about. Then we will have a session on cross-examination, and then we will proceed like that. We'll notify you. So I think that my class was so convincing that you don't have any questions. So thank you.
Thanking everyone has become a formality by now, but at any rate, I thank Advocate Johnson Gomez sir for his class and his insight into this session. And I also thank the participants for their patience and discipline. There was one thing that I wanted to point out. There was this discussion about the usage in the WhatsApp group. We've kept it without any admins or restrictions so that there will be some productive discussions, and we would like to keep it that way. And as regards to the module also, we hope that everybody will be making good use of the module by using the user ID and the access that we have provided you, because obviously those materials will be of better use to you only if you take a look at it and then come prepared for the next session. So I encourage you to do that, and I thank you all. Good evening.
Sir, will these PowerPoint presentations be shared at the group?
Which one?
These PowerPoint presentation, these slides, will it be shared at the group?
Yes, it will be shared.
Thank you, sir.
The people in the online group is our students of PCL and not Kerala High Court Advocates Association members. Kerala High Court Advocates Association members are expected to be here in the in the hall. That is the understanding that we have reached of late. One more thing we wanted to tell you, we are uploading a document that is on award writing. Award writing is one of the important key things. We will be sharing with you the first paper of paper for your award writing. Award writing is the assignment which will assess your participation. And this materials is a study material for you to read through and have an understanding as to how you approach an award. Probably most of you can use this while you become a judge of any courts, because this is a very crucial part of arbitration awards, because arbitration awards are being prepared for three people. One is for the persons who have paid you. They want to know what happened to their case. Then the second is the party should know. The higher court should know how you have assessed this. So these are the two important stakeholders apart from the person who has prepared. So how to prepare an arbitration award is one aspect, and we will be loading that in the Moodle platform, and we will be sharing with you. And also the first paper. The second part of the assignment will be shared after you read the study materials, and that will be in the nature of an examination type of arrangement, where we will supply you the second part, which will contain the evidence and hearing notes of the respective counsels. So you can write the award in a classroom environment, and let us see how good your arbitration awards are going to be. Thank you.